Good morning, Apurva, and good morning, everyone. On behalf of Gemtech School of Law, I welcome our today's guest of honor, Advocate Keshav Gaur. He's an alumni of our college, and he's very intelligent and a very dynamic person. And he's very close to my heart. He's one of my favorite students also. And I wish him all the best for this webinar today. Hope this webinar is going to be very interesting and informative for you all. And with this, I just once again welcome our guest, Keshav Gaur. Now over to you, Apurva now.
Thank you so much, ma'am. Now, without wasting much of our time, here I welcome Mr. Keshav Gaur to kindly start with the webinar, please.
I hope I'm audible.
Yes, sir, you're perfectly audible.
And the video quality is also perfect, I guess.
Yes.
Thank you, Purva. First of all, the head of the department, Dr. Pallavi Gupta ma'am, Dr. Richa Srivastava ma'am, Professor Rahul Arora sir, and all the committee members, organizers, and the today's participants in the webinar. It's a matter of great pleasure and joy to be here again with this institution, because we are part of this institution since 2014. And I would like to thank HOD ma'am, Dr. Pallavi Gupta, for inviting me to give lecture on today's topic, that is Doctrine of Self-Incrimination vis-a-vis right to silence. So first of all, I would like to start what actually self-incrimination is. Let's know the general meaning of self-incrimination. Self-incrimination basically means to incriminate oneself. To incriminate oneself. That is, suppose someone compels a person to give evidence against himself. That is, you go and give statement or any kind of evidence against himself in a criminal proceeding. That criminal proceeding may be a criminal trial, or maybe a criminal investigation, or that may be a criminal inquiry. So this was the general meaning of self-incrimination, means to incriminate oneself. Now further we will be dealing with the several provisions which are related to self-incrimination, and what is the constitutional aspect of self-incrimination. So I would like to confirm that am I allowed to share my screen? Please confirm that.
Sir, you are the co-host. I believe you have those rights.
Okay. Thank you so much, Apurva. Now, before moving further, I would like to start with the constitutional aspect of the self-incrimination. Basically, you all must be aware that self-incrimination is a protection given to an accused. Rather, I would say that it is not only available to an accused, but also available to a witness, also available to a suspect. And how it is available to a witness, how it is available to to the suspect, I will be dealing in my further presentation. So. As you all know that Supreme Court, as you all know that Constitution of India is the supreme document of this country, and nothing can go beyond the Constitution of India. So there are certain practices. In fact, there were certain practices that were prevalent in this country prior to existence of Constitution of India. In 1950, we got Constitution of India. Before that, there were certain practices such as compelling a person to give witness again to be a witness against himself, or compelling a person who is a suspected in a crime to give statement against himself. So, in order to curtail those practices, it was required that there should be certain protection given to such accused or such persons. In furtherance of that, we had a certain provision in Indian Constitution. We also had certain provision in CRPC. We also had certain provision in the Indian Evidence Act. So with all those interconnection, I will be dealing in my presentation, and I hope you all have read Article 20 of the Indian Constitution, which is providing the constitutional backing to this doctrine of self-incrimination. So give me a second. I'll present Article 20, subclause 3 in front of you. So Article 20 basically deals with the uh, just a second. Article 20 was basically inserted in the Indian Constitution to give protection to the accused, to save them from various atrocities which were faced by the accused at the time. So it was thought by the constitutional framers to add certain provision in the Indian Constitution to have a look, to have a check upon these practices which were against their dignity, which was against the against the human nature of this country. So, in order to curtail those practices which were affecting the fundamental right, which were affecting the basic rights of an individual, Article 20 was added, and further Article 20 subclause 3, which is the prime focus of our presentation today, that is the doctrine of self-incrimination. Self-incrimination was brought into picture in India by virtue of Article 20 subclause 3, which read as no person accused of an offense shall be compelled to be a witness against himself. Here they are referring that no person. Here they are referring that no person accused of any offense. Accused of any offense. They are referring just one person who can avail this protection under Article 20 subclause 3, and that person is he must be an accused of an offense. So I talked about certain other persons, which were witnesses, which were suspects. They also get the protection against self-incrimination, but not under Article 20 subclause 3. But there are certain other provisions where they can avail this protection that I will be dealing later. So,
Excuse me,
uh,
sir.
hello,
Sir, the PPT is not visible.
sorry.
Sir, the PPT is not visible.
Actually, I'm not showing PPT. Actually, I've shared my screen. It is basically the Bare Act, Article 20, subclause 3. Is it visible?
No, sir, the bare actors are not visible.
Apurva, can you look into the matter? Because I suppose I was the co-host, and being a co-host, I can share my screen. Can you please look into the matter, Apurva?
Yes, sir. Yes, sir. Can you please repeat, sir?
Uh, Participants are saying that they are unable to see my screen.
Sir, actually, your screen is visible, but not the PPT. If you are
I'm not sharing any PPT.
right.
I'm just sharing my screen, and on my
Yes.
screen there's Article 20 subclause 3. Is it visible?
No, sir. There is no such article visible. Actually, I can just see some of the folders while you have shared your screen.
Just a minute, just a minute. I hope it is visible now.
Yes, sir, it is
Purva,
visible now.
I hope it is visible now.
Yes, yes.
Uh,
Yes, sir, it is visible now.
let's continue, I guess.
Yes, sure, sir, please.
So I was talking about Article 20, Subclause 3, which was inserted in the Indian Constitution just because it was needed. The moment we got independence, we realized that earlier the accused or the people who were a suspect of a crime were facing certain atrocities from the investigation agencies. And one such atrocity was the compulsion to incriminate oneself, and to avoid those compulsion to incriminate oneself, to avoid those practices, Article 20 subclause 3 was added. So Article 20 subclause 3 is in front of you. It read as no person accused of any offense shall be compelled to be a witness against himself. Here they are referring no person accused of any offense, means the persons which I discussed earlier, that who all can avail this protection were accused, witness, and the suspect. But Article 20 subclause 3 provides protection just to the person who are accused of an offense. So how a witness or how a suspect of a crime can avail this protection, we will be dealing it later. I'll support my argument with the relevant provisions later. But for now, we should focus upon Article 20 subclause 3 and its why it was inserted, or why it what is the constitutional essence behind Article 20 subclause 3. So the main objective of Article 20 subclause 3 was to provide the protection to the accused who were compelled to give statement, who were compelled to give testimony to the investigation agency against themselves, which can be used against themselves. Now, if you interpret this subclause 3 further, you will get three requirements which need to be fulfilled before availing this protection. Those three requirements are that the person should be accused of an offense. Person should be accused of any offense. Second requirement is that he should be compelled to be a witness. He should be compelled to be a witness against himself only. And the third requirement is that it should be with the purpose of he should have been compelled with the purpose to use that statement against him only in any criminal proceeding. So these three requirements need to be fulfilled before availing this protection. And before moving further, I would like to focus upon the word compelled to be a witness. Now, how can we interpret the word witness in this clause? Being a witness against oneself means, in criminal jurisprudence, being a witness against oneself means to furnish evidence. Being a witness means to furnish evidence in a criminal proceeding, to provide evidence, and that evidence can be of any kind. It may be oral evidence, it may be documentary evidence, it may be even material evidence. Oral evidence can be in the form, oral evidence is generally in the form of testimony, the statement given by an accused, or the documentary evidence is in the form of the documents. And material evidence can be in the form of any kind of material. For example, if a crime is committed and the accused used a certain weapon in order to commit that crime, then that weapon becomes a material. That weapon becomes a material evidence. So these are the three kinds of evidence which can be provided or which can be furnished in a criminal proceeding. So if we look into this provision, then it basically provides protection just to accused of any offense. And compulsion is the main element to avail this protection. Compulsion is the main element. Compulsion from whom? Compulsion from the investigating agencies, or compulsion from the court, or compulsion from the person who is having the authority of that accused. So person who is having the authority of that accused can be any person. He can be court, he can be a police officer, or any other investigation agencies. Now, though I plan to discuss certain provisions which are connected to this doctrine, which those provisions are from CRPC and the Indian Evidence Act. But I would like to discuss one provision from the Indian Evidence Act in order to clear the basic concept, to build a basic concept of this doctrine, because you all must be in a dilemma that I was talking that this protection is available to accused as well as witnesses. Now, how a witness get protection? Because Article 20 subclause 3 nowhere talks about a witness. Article 20 subclause 3 nowhere talks about a witness. It is just talking that person should be accused of any offense. So a witness is provided protection from the self-incrimination in section 132 of the Indian Evidence Act. I was informed that most of the students in this webinar are not have not read Indian Evidence Act or CRPC so far. So I decided to provide the provision on the screen itself. And here I want to share my screen. Uh, that shall carry section 132 of the Indian Evidence Act, so that it becomes convenient for you all to get into the provision and to interpret along the side. And let me share just a minute. Just a minute. So basically, this doctrine, the main purpose of this doctrine was to curtail certain practices. Even CRPC also deal with it, but we'll be dealing with it later. CRPC also prohibits such kind of practices, and if anything go against the basic fundamental principles of the Indian Constitution, anything go beyond the basic structure of the Indian Constitution, then that should be declared void. That should be declared void, as has been held by Honorable Supreme Court in Keshwananda Bharti. I'm sure that you must have read that judgment, or you must have heard about that judgment, where it was declared that anything or any practice or any law which get backing from the legal statutes, and it is against the fundamental rights or basic principles of the Indian Constitution, that should be declared void. In the same line, Article 20 clause 3 was added to ensure that any such practices which were prevalent, they should be curtailed, and they should be declared void. So one of such provision was Section 132 Indian Evidence Act. Section 132 Indian Evidence Act. I hope you all can see that. I hope you all can see that Section 132 of the Indian Evidence Act. Now, Indian Evidence Act 132 read as witness not excused from answering on the ground that answer will criminate. It basically talks about that witnesses who all are part of a criminal proceeding, they shall not be excused from answering. They shall not be excused from answering on the ground that such answers which they will answer in a criminal proceeding will criminate themselves. Now you must be wondering that how is relating Article 132, which is totally opposite to the doctrine of self-incrimination. If we read further in this section, you'll find that the witness shall not be excused from answering any question as to any matter. Witness shall not be excused from answering any question as to any matter relevant to that matter in issue in any suit or in any civil proceeding, civil or criminal proceeding, upon the ground that the answer to such question will criminate or may lend directly or indirectly to criminate such witness, or that it will expose or tend directly or indirectly to expose such witness to penalty or forfeiture of any kind. the main provision, Section 132, puts a mandate upon a witness that he should be giving all answers accurately, whatever is within his knowledge, and he cannot refuse to answer that such answers will incriminate him, such answers will go against him in a criminal proceeding. But our main focus is the proviso. Our main focus with the our main focus with respect to the topic we are discussing, that is doctrine of self-incrimination. Our main focus is the proviso to section 132, which provides that no such answer, the answer which was given by a witness in a criminal proceeding, a witness giving a statement in a criminal proceeding shall be used, provided that no such answer which a witness shall be compelled to give. Means 132 main proviso, in 132 main proviso, where a witness was asked to give certain statements, if he was compelled, the main element here is the compulsion, which I discussed in article 20 subclause 3, that to avail the protection of doctrine of self-incrimination, one must prove that there was a compulsion. So the same compulsion is talked about in article 132 proviso, which says that no such answer which a witness shall be compelled to give shall subject him to any arrest or prosecution or be proved against him any criminal proceeding, except a prosecution. This is something not relevant at this stage. What relevant for us is that the witness who was answering any question in a criminal proceeding, if he was answering those questions under a compulsion, and then those answers were taken from him, then those answers cannot be used, those answers cannot be used against him in a criminal proceeding, and those answers shall not subject him to any arrest or prosecution or to be proved against him in a criminal proceeding. So from this I can conclude, that sorry that basically doctrine of self-incrimination is available to both witness as well as the accused. Now the suspect remains. How it is available to suspect, that also I will deal later, but for the time being I can conclude that these two persons can avail the protection under article 20 subclause 3 and under section 132 of the Indian Evidence Act respectively. uh, I hope everything is going smooth and there is no technical fault on my part. And let's continue with the constitutional aspect of the topic. Uh, so, why there was a need to insert such provision? Why there was the constitutional makers thought, because one reason was that the accused and the witnesses were facing atrocities. The another reason which the Supreme Court, honorable Supreme Court, in various judgments have interpreted, they have laid down that such practices have led to violation of certain fundamental rights provided to the individual. Now I'm talking the fundamental rights provided to individual. You must remember that fundamental rights are provided to each and every individual, no matter whether he is accused or he is a convicted or he is an innocent person. What matters is the level or the number of rights provided. And a convicted person will be having certain limited rights, but a person who is accused or who is innocent, the accused will be treated as innocent until proven guilty. The criminal jurisprudence says that the accused will be considered to be innocent until proven guilty. So will not that be unjustifiable on his part, that we are curtailing his basic rights which are provided to an individual? Will not that be injustice to that accused who has not yet been proven guilty, who has not yet even been tried in the court of law, and we curtail his basic fundamental rights? His article 21 will be infringed. You must be knowing that article 21 talks about right to life and personal liberty. Now, mere saying that the person is having right to life and personal liberty will not do. In fact, there should be certain executive actions that ensure that, yeah, there are certain rights. Yes, there are certain rights which are available to the accused or any individuals in violation, in violation of those rights. They can approach Supreme Court under various provision of the Indian Constitution. So, uh, how we can relate the doctrine of self-incrimination with Indian with Article 21, that is right to life and personal liberty. A right to life, basically, it not only refers to mere existence. Suppose I took birth in this family, and now I'm simply existing. I'm simply existing. That does not mean right to life. Supreme Court, Honorable Supreme Court, have interpreted that right to life is not limited to mere existence, but it also means a dignified life. Now, what does a dignified life means? A dignified life, as per the Supreme Court, in various judgments, uh, will include the basic amenities, the basic fundamental protections, the basic fundamental rights. For example, right to privacy, for example, right to health, for example, food, shelter, etc., etc. And out of those fundamental rights, one such fundamental right is right not to be tortured. Now, nowhere in the Indian Constitution, nowhere in the Indian Constitution, it is declared that right to privacy or right to food or right to shelter is a fundamental right. Nowhere it has been declared. But this is the concept. This is the concept. Concept. These rights have evolved from the concept of implied fundamental rights. Now, what are implied fundamental rights? Basically, when the Constitution was drafted, it was not possible for the constitution framers to write each and everything into the Constitution. And it is quite logical also that you cannot write each and everything in a thin document. If you go and interpret Article 21, then it may take several thousand pages to write what all is included in Article 21. So it was not relevant or nor logical at the time to write each and everything in Article 21. So the constitutional framers left it to the Honorable Supreme Court to interpret this Article 21, and to interpret Article 21, and take out the or evolve certain fundamental rights, which are the essential, which are the basic amenities which a person should have to live a dignified life. Because it is the job of the Constitution, because it is job of the Supreme Court to dig inside the Constitution deeply and take out the fundamental rights which are impliedly given in several provisions. And through this practice of evolving certain fundamental rights which were already there in the Constitution, the Honorable Supreme Court came up with the one such implied fundamental right, which was right not to be tortured. So, right not to be tortured is a part of your dignified life. When when right to life and personal liberty is available to each and every individual of this country, then why should not an accused or a suspect or even a convict get such right? Because every human being has a right to live with dignity. Therefore, in order to protect his dignity, they thought, the Honorable Supreme Court thought, that there should be certain right that need to be evolved. That this right was already in existence, but what Supreme Court did, they just took out from Article 21. They interpreted Article 21 in such a way that they got to know that the right not to be tortured is one such right, which is an essential part of our dignity, which is an essential part of a dignified life of a human being. Therefore, this are the topic of the day, that is self-incrimination. Self-incrimination is a person is protected from self-incrimination under the right not to be tortured as provided in Article 21. Now, I would like to bring it to your kind notice that Article 21 carries, or rather, Article 21 contains all those fundamental rights which are available to an individual. For example, right to life, freedom of speech, Article 19, Article 15. They all are impliedly given in Article 21. It's that Article 19, 14, and 15, etc. They are just expressly mentioning those rights. They are just expressly mentioning those rights in the Indian Constitution. Otherwise, if they would not have been there, then Supreme Court would have interpreted Article 21, and those rights are impliedly given. Mind my words, those rights are impliedly given in Article 21, and upon interpretation, such rights are evolved by the Supreme Court. For example, the right not to be tortured, as we are discussing. Now, this torture can be of can be of two types. It can be of physical torture. It can be a mental torture. Physical torture, you must all be aware. You must have seen various movies. You must have seen various incidents. You must have heard about various news that that accuse or the suspects people they are they are caught by the investigation agencies, and they are put in certain environment which is of such a nature that person feels that there is a need to disclose whatever he know. There is, otherwise he would be subject to certain atrocities. Those atrocities can be of any kind. So I can take an example of a police station has such an environment, that people that are normal person like you and me, no matter we are an advocate, but and you are a budding advocate, but if we still move to a police station, then that police station contains such a vibe, that police station has such an environment that normal person will feel an element of compulsion there. Normal person will feel an element of threat there in that environment. Due to that threat due to that threat, he is compelled to say whatever the investigation agencies want them to say. So this is a kind of physical as well as mental. Another example for mental torture is example. For example, I suppose I am an investigating officer, and I asked you to uh, confess before me. Otherwise, I will subject your family to harsh beating, or I will arrest your family. I will arrest your old parents. Then the person has a mental stigma in his mind that no, if I would not confess in front of him, he will subject my family to cruelty. Instead of doing that, I should confess and I should go behind bars. This is the basic element of compulsion. Sorry. This is the basic element of compulsion which makes that accused or a witness to provide evidence against himself in any criminal proceeding. So in order to curtail these practices, in order to protect that accused who was under threat, who was under compulsion to be a witness, to give statement against himself, to provide evidence against himself, the concept of right not to be tortured evolved by the honorable Supreme Court while interpreting Article 21. Therefore, therefore, I can say that Article 20 subclause 3, Article 20 subclause 3 is the extension of Article 21, that is right to life and personal liberty. This was the dimension of a dignified life. Now, another dimension in Article 21 we will talk is the personal liberty part. But before going into personal liberty, I would like to bring certain points with respect to dignity. Now, dignified life refers to dignity, and dignity contains one of the element that is known as individual autonomy. Dignified life means to live with dignity, and dignity contains one such element that is called individual autonomy. Honorable Supreme Court in Justice K.S. Puttaswamy judgment have very elaborately discussed this concept of individual autonomy. Now, what does individual autonomy refers to? Individual autonomy basically means that a person's own will to do something or not to do something. I must be having power to. I must be having a power to decide my own. I should not be compelled by some other person that you must do that or you must not do that. Means individual autonomy simply refers to that I am allowed to do what I want to do, and I am not compelled to do what I am not what I am not what I am not decided to do, or what I am not willing to do. So this is basically the concept of individual autonomy. Now try to relate this concept of individual autonomy with the doctrine of self-incrimination, where an accused is subjected to criminal proceeding. He is subjected to investigation. Now, as per Justice K.S. Puttaswamy judgment, he is supposed to have individual autonomy. He should not be compelled to disclose what he do not want to disclose. He should not be compelled to disclose or say. He should not be forced to do something or forced to give such statement which he is not willing to do. Therefore, individual autonomy forms a part of dignified life, and dignified life forms the part of Article 21. And if Article 21 is violated, if Article 21 of an individual is infringed, then ultimately you can say that Article 20 subclause 3 is violated, because Article 20 subclause 3, that is doctrine of self-incrimination, is impliedly given in Article 21. Now, this was about right to life, the dignity or the dignified life aspect. And now, why these rights, the dignity, dignified life, individual autonomy, why these are provided to these persons? Because they have committed certain crimes. They are part of an investigation. Why they are provided such wide rights to them? Why they are providing such wide rights to them? Now, when Supreme Court was interpreting this dignified life and certain various judgment with respect to self-incrimination, Supreme Court focused that these accused persons are not a convict yet. They are still a suspect, or they are still the accused who are undergoing a trial or undergoing an investigation, and they are yet to be convicted. Therefore, as a law of criminal jurisprudence, as a rule of criminal jurisprudence, they should be treated as innocent until they are proven guilty. Therefore, these rights should be guaranteed to these individuals. Now, what all is covered under Article 21 that I'll be dealing. Before that, I would like to refer to certain examples where the accused persons, especially the accused and the suspect of a crime, not a witness, but accused or the suspect of a crime, is subjected to certain tests. Because what I am trying to deal with now is the privacy part, which is also the part of Article 21. Now, right to privacy, as was held the fundamental right in the Justice K.S. Puttaswamy judgment, that right to privacy is a fundamental right of a person that should be guaranteed in all circumstances. Now, that right has been infringed through various tests. These tests are conducted upon the accused or a suspect, and they are subjected to such inhuman treatment, such cruelty that their right to privacy, not only right to privacy, but their right to live a dignified life is under threat. But their basic human existence is under threat, because these tests are not only subjecting them to certain procedure or certain steps, but they are mentally affecting them. They are mentally torturing them by conducting such tests. And these tests are narco analysis, B test, polygraph test, etc. Now, I'll talk in very brief about these tests. What are these tests? So first test is the narco analysis test. Narco analysis test. In this test, the accused of a crime is subjected to given the sodium pentothal plus water. Sodium pentothal is a chemical which is given to this accused with water. Water plus sodium pentothal is given to the accused. Now this test is basically conducted. This test is basic. The main purpose of this test is to know whether the accused is telling truth in the investigation when he is in fit state of mind or not. To check the veracity of the accused, whether he is saying true or not. To check that they conduct narco analysis. So by administering this chemical, that is sodium pentothal plus water, to the accused goes in the subconscious state, and in that subconscious state, when any question or anything related to that crime is asked to that accused is unable to decide whether to malafidely change his statement or not, because he has lose control over his mind. He has gone in subconscious state. Now he cannot decide whether to alter his statement or not. So whatever he will say in that state of mind, that all will go without any modification. And that statement gathered from that accused can be used against him. Now this was something you can say that harsh or cruel to that person's dignity, that person's basic fundamental right, because he is not willing to allow anyone to enter in his mind, because he also have right to mental privacy. So these kind of tests are very inhuman in nature, and violates their fundamental right provided under Article 20, Subclause 3. Another such example is polygraph test, popularly known as lie detection test. Now, in this person is subjected to the polygraph test, and whenever he speaks or gives a false statement with respect to the crime or with respect to the criminal investigation he is subjected to, then his pulse rate will show a major variation. His pulse rate will show a major variation. The moment that major variation comes, it will show that on that particular question or statement, that person, that accused, is telling lie or is not giving a true statement. He has altered his statement. This is the polygraph test. And another example I was referring to was the beep test. Beep test is also popularly known as brain mapping test. In this brain mapping test, he is subjected to the procedure of brain mapping, and he is shown an animated video related to that crime. He is shown animated video related to that crime, and when he sees that, when he have a look at that animated video, if that if his mind does not show any major variation, if his brain does not show any major impact after seeing that video, then it shows that the person has earlier witnessed that incident or was part of that incident or that crime, and he has seen that particular scene earlier also. That is why the brain is not showing a major impact. So thereafter you can say that the person is somehow connected to the crime. He may be a witness or he may be accused also. So in order to further their investigation, these investigation agencies apply to the court for these kind of tests, but the courts in this regard are very reluctant to provide, are very reluctant to allow these kind of tests, because it is very obvious that these results are obtained. These results are obtained. These are not in the nature of oral statement. These are not in the nature of written statement. They are something which are taken by compelling a person, and he involuntarily, he was not willing to say. It was taken through compulsion or by making him to do that thing forcefully. By that process, he was that particular information was gathered from that person. These tests does not involve the positive volition act of the accused. Positive volition act refers to that person was not willing, was not voluntarily giving that statement, but he was administered something, or he was subjected to such procedures which made him do so. Means he was forced to do so. So it violated his Article 21. It violated his basic fundamental rights. It violated his dignity. It violated his Article 20 subclause 3, which protects him from the self-incrimination against such practices. So these tests are not very much prevalent in India, and the courts are very reluctant in allowing these kind of tests, because they are against the basic fundamentals of the Indian Constitution, and hence these tests should not be treated as a valid testimony. These tests, the information gathered from these tests should not be treated as a valid testimony. Now, one aspect of these tests was the violation of fundamental right. That is the major fundamental right, that is Article 21. One aspect was that it violates Article 21, right to life and personal liberty. Now, within that particular right, one more aspect is the right to mental privacy. Since they are cruel, they are harsh, by entering into a person's mind by scientific technology like brain mapping, or we discussed narco analysis. By using those technologies, you are entering into a person's mind, and therefore you are infringing his right to mental privacy. And that right to mental privacy has been upheld by Honorable Supreme Court to be a fundamental right under Article 21. And if you violate Article 21, then ultimately Article 20 subclause 3 is also infringed. Because uh, because you must agree upon this point that it is very obvious that what I am not willing to disclose in my conscious state, in my conscious state, I would not be willing to disclose the same in my subconscious state. It is quite obvious. But if that is done forcibly, then it is against my rights, and hence that should not be taken as evidence against me in any criminal proceeding. So this was the constitutional aspect of these tests. The three examples I gave, where where the privacy is affected of a person. Now, if we refer to criminal procedure, if we refer to criminal procedure, there are certain provisions which also guarantee the protection from self-incrimination, that I'll be dealing when I will take certain interlinkages between the provision with respect to self-incrimination. But one such provision is 161, section 161, subclause 2 of the CRPC, which is in line with Article 20, subclause 3. That also basically talks about that a person should not be compelled to be a witness against himself. Therefore, if you are conducting these tests upon a person, it not only violates it not only violates Article 20, subclause 3, or Article 21, that is right to life and personal liberty, but it also violates the mandate provided by the Code of Criminal Procedure under Section 161, subclause 2. So these kind of practices, these kind of tests are not very appreciable in the criminal trial. So because they are against the Indian Constitution, the fundamental principles of the Indian Constitution. Keshwananda Bharti case, the Honorable Supreme Court held that anything that violates the basic structure of this Constitution should be declared void, should be declared void. That is why these practices which are affecting, because right to privacy, right to speech, right to live a healthy life, dignified life, these are the core of the Indian Constitution. These are the basic principles. If these are violated by any procedure or these or by any law in India, they should not be declared as valid. Rather, they should be struck off, or these practices should be stopped. And in that regard, the legislature brought Section 161 subclause 2, which was already in existence before the Indian Constitution came, and same provision in line with Article 20 subclause 3 we found in Section 132 of the Indian Evidence Act. Now, this was the constitutional aspect of uh, doctrine of self-incrimination. Now, what if the person gives the statement? What if the person gives this statement which may incriminate him in a criminal proceeding voluntarily? Means he is willing to give such statement. He is not compelled. He is not forced by someone to give such statement. He realized his fault. In guilt, he went to a police station. He confessed there, or he confessed before the magistrate that I committed so and so crime. Now he know that these statements may incriminate him. These statements may go against him. Now, will he still be protected under Article 20 subclause 3? The answer is no, because there is no use of availing protection under Article 20 subclause 3 when the person is willingly going to the authorities and giving such statements which may be used against him in an evidence, as an evidence in a criminal proceeding. Therefore, the element of compulsion, I also discussed that this element in my initial presentation, that compulsion is the must for availing this protection. That that the person should be compelled to do so. Compelled to do what? Compelled to give evidence against himself. So, if a person voluntarily conducted, if a person get himself voluntarily subjected to these tests, that is polygraph test or the narco analysis test, if he is willingly going there and he has agreed to go under those tests, then those tests are not unconstitutional. Then those tests are not unconstitutional. But an exception comes here, that those tests cannot be those tests cannot be used against such person. Those tests cannot be used against such person in evidence, except except where the statement results into a discovery of some object or discovery of anything related to the crime. Now, this exception has been provided in 162 subclause 2 of the Code of Criminal Procedure. I would like to repeat this point, that where a person is voluntarily subjecting him to these tests, the polygraph test, the narco analysis test, etc., if he is subjected to this test willingly, he have given consent, and then during that process he gives any statement that may be used against him or that goes against him in a criminal proceeding, then those statements are not unconstitutional per se, but those statements cannot be used. This is an exception that those statements still cannot be used against that person, that accused, which which may go against him in a criminal proceeding, except the discovery statement. Now, what does a discovery statement refers to? Discovery statement basically means, suppose I made certain statements before the investigation agencies, and out of those statements, one statement referred to the disclosure of some weapon or disclosure of some article associated with the crime. Now, when that article is discovered by or with the help of the information provided by me, then that, and when that discovery is made, then that statement which helped to discover that particular article or the crime weapon, then that statement becomes the discovery statement. Therefore, coming back to our point, a discovery statement a discovery statement gathered from these narco analysis test or the polygraph test, etc., they can be used against the accused. They are valid. They can be used in a criminal proceeding. But other statements which are even given voluntarily, when the person was subjected to these tests voluntarily, when he consented for these tests, those statements cannot be used at all, cannot be taken into consideration in any criminal proceeding. So this was an exception to the general rule of the doctrine of self-incrimination. That is where there is no compulsion. It cannot be used. It cannot be used. But the discovery statement made by the accused can still be used against the accused. This is provided under 162 subclause 2 CRPC. And now Article 21 was talking about right to life and personal liberty. Now, life was referring to dignified life that we have already discovered. Now, what does personal liberty means? What all is covered in personal liberty? Does it only extend to some physical things like uh, uh, I have personal liberty to move in this room. I have personal liberty to stretch my arms. I have personal liberty to go outside and walk on the road, walk in the streets. I have personal liberty to enter into any shopping mall, etc., etc. Does it imply that it is limited to that physical personal liberty, or it also include the mental thoughts? It does it also include the liberty upon my mental thoughts? Actually, the Supreme Court have interpreted this article in various judgments, and one interpretation refers to this point, which clearly mentions that Article 21, with respect to personal liberty, is not limited to some physical things. It also it also extends to mental thoughts. Mental thoughts, for example, I can think I am free to think that how should I go from this place to that place, or how should I talk to my friend, whether by phone or by webcam or by any other mode. I have my personal liberty to think. I have my personal liberty to think. And that personal liberty also extends to doctrine of self-incrimination. Now, how does that self-incrimination is associated with personal liberty to my mental thoughts? Supreme Court held that to keep my knowledge with me, to keep my knowledge with me also falls under the personal liberty guaranteed under Article 21. Now, what does that mean, that to keep my knowledge with me? To keep my knowledge with me means that whatever I know, whatever is there in my mind, whatever knowledge I have, it is up to me that whether I should give it, whether I should bring out or not. It is up to me. This is my personal liberty. Now you cannot say, now this does not refers to the students of any college. For example, our college, that they are exercising this right in university exam, that no, I'll not produce my answer on the answer sheet because I have right to keep my knowledge with me. That is not the context here we are talking about. This is to keep my knowledge with me refers to whatever it basically refers to the doctrine of self-incrimination, that whatever I know about the crime or whatever I know about the incident which is a part of a criminal proceeding, and if that knowledge might go against me, if that knowledge might go against, if that knowledge is produced before the investigation of the agencies that might go against me, then that knowledge is my personal liberty. I have my personal liberty to disseminate that personal knowledge, and I am free not to disseminate that personal knowledge. The Supreme Court very clearly observed in that judgment, and the judgment of Selvi and others versus State of Karnataka, that I cannot be compelled. A person cannot be compelled to keep to disseminate a knowledge which he possess. Therefore, a person who is an accused, therefore a person who is a witness, who is subjected to a criminal proceeding, cannot be compelled to give any information or to give any evidence against himself, or give any statement that may be used against himself in any criminal proceeding, because he have various right, as I have discussed earlier. He have various right, article 20 sub clause 3. He has various right, article 21, right to life and personal liberty, dignity, to live a dignified life, article section 132 Indian Evidence Act. And out of those right, one such right is to keep my knowledge with me, that is guaranteed under the word personal liberty, that has been derived from the word personal liberty, and personal liberty also extends to mental thoughts that are inside my mind. I am free to bring out those mental thoughts, and I am free not to bring out those mental thoughts. Therefore, an accused cannot be compelled, or a witness cannot be compelled to bring such information out of his mind, just to furnish the investigation officer in his investigation. So this was the dimension of Article 21, how it is related to the doctrine of self-incrimination, and how a person who is getting the right under Article 20 subclause 3 can also avail, is also having a right under Article 21, which is a broader right, and out of that Article 21 only we got Article 20 subclause 3, because that is implied in that Article 21, right to life and personal liberty. Now I would like to narrate a story before moving to a further point. Now, there were at a time there were three children. They belonged to a particular community. Now, basically, they were school-going children, and these children's uh, uh, whenever they stand in a morning assembly that are being conducted in the schools, morning prayers we call them. During that time, at the end of the morning assembly, a national anthem is sung by the assembly. These three children never sang national anthem in the assembly. Now, one fine day, they were noticed by their teachers, and the matter was reported to the higher authorities. When the matter was reported to the higher authorities, they decided that this is something against our national anthem, our national sentiments, and these students were called and were guided to not to repeat this in future, and they have to sing, because it was compulsory, the singing of national anthem. Hello.
Yes, sir, please continue with the webinar. Some of the participants got unmuted.
Okay, okay. So, so these children were called before the higher authorities, and they were instructed that they should not repeat this, and they must sing national anthem because it was compulsory for each and every student to sing. But again, they didn't sing. They were standing in respect of the national anthem in the school assembly, but they never sang. Now the higher authorities expelled them from the school on this ground that they have disrespected the national anthem. Now, one of the one of the child's father was advocate. He reported the matter to the before the court that my child has been expelled from the school on this ground. Now the matter finally went to the Supreme Court, and there the Honorable Supreme Court dealt with the issue that whether the singing of national anthem, whether the singing of national anthem in uh, a school assembly, as it was in this story, was a compulsion or it was, and whether it amounted to disrespect to the national anthem. So basically, this story is nothing but these are the facts of a case popularly known as Bijoy Emmanuel versus State of Kerala, 1986 Supreme Court. Now, in that case, these three students approached Supreme Court, and there they contended that, sir, we showed respect to the national anthem by standing in the assembly in respect of the national anthem. We gave respect, but the community to which we belong, that is Jehovah community in Kerala, they belong to that community. That community have a belief that they will not sing any national anthem or involve in any practice that may promote the such kind of activities like singing national anthem, etc. So these were certain restrictions in their community. Now what Supreme Court interpreted was that since the students uh, showed respect to the national anthem by standing in the assembly, that was sufficient. And along that, the Supreme Court also held clearly that when a person has a right to life, when a person has when a person has freedom of speech and expression under Article 19 subclause 1, there itself the person has a right to remain silent, the right to remain silent. The Supreme Court in this judgment evolved the concept of right to remain silent, and from there we got a right to remain silent, and we used that fundamental right uh, with the doctrine of self-incrimination. Therefore, if you are compelled by any person, or particularly the investigation agencies or the court, to speak something that may go against you, there you can exercise your right to remain silent. Because if the Constitution is providing you right to freedom of speech and expression, then the same then the same provision also provides you the right to remain silent. Therefore, this was the constitutional dimension of Article 20, constitutional dimension of Article 20 subclause 3. That is, we refer to doctrine of self-incrimination, and that is how we connect this article with the right to remain silent. Uh, Basically, right to remain silent and self-incrimination both are ensured in Article 20 subclause 3 itself. But as I have discussed with you, that Bijoy Emmanuel judgment, where the Honorable Supreme Court manifestly declared that a right to remain silent is also guaranteed under Article 19 subclause 1 subclause A. Now, before proceeding further, I would like to refer to Article 20 subclause 3. There we left certain interpretations which are necessary to be discussed while dealing with the doctrine of self-incrimination, because without those interpretation, the topic remains it would not be justice to the topic if those interpretations are not discussed with you. Therefore, I'll share Article 20 subclause 3 again with you, and yeah, just a second. Yes. This part we have already discussed, that no person accused of any offense, that this protection is only available to the accused of any offense, and the compulsion element we have discussed, and the meaning of being a witness. We have discussed that being a witness means basically to provide evidence against oneself. Now, what else is remaining in Article 20 subclause 3? That what about a suspect? What about a suspect who is yet to be basically suspect is a person. Basically, suspect is a person who is not yet been a part of investigation, who is not yet been a part of the investigation, but the investigation agencies have a doubt that the person X may somehow be related to this crime, or he might have committed this crime. That suspicion upon that person makes that person a suspect of a crime. Now, it is not expressly given in Article 20 subclause 3 that a suspect will also be covered under the definition of accused of any offense. But the Supreme Court, in its judgment in MP Sharma versus Satish Chandra, while deciding the scope of Article 20 subclause 3, clearly mentioned that it not only covers the accused of any offense, but it also includes a suspect. It also includes a suspect of any offense. Therefore, if a suspect who is being compelled to be a witness against himself he may avail he may avail the protection against self-incrimination under Article 20 subclause 3 itself. So this was the how a suspect is getting protection under Article 20 subclause 3, along with the main accused, along with the accused who is subjected to the criminal proceedings. Now, what about the testimony? What about the testimony? What kind of testimony or what kind of statement is referred to in Article 20 subclause 3? The term to be a witness includes all three kind of evidences: oral, documentary, and material evidence. But for the purpose of doctrine of self-incrimination, I should make it clear that doctrine of self-incrimination is only available for the oral evidences. That is the oral testimonies or the oral statements made by the person in who is under the compulsion. Therefore, therefore the phrase to be a witness will only cover the testimony, that is the oral statement given by the accused, the person who has given the oral statement. Only that person can avail this protection under 20 subclause 3. Now, what does that oral statement refers to? Can any oral statement be covered under Article 20 subclause 3? Any statement, by any statement I mean, can I compel someone to suppose a person is under a police custody and he is being compelled to tell his best friend's name? Is it being covered under Article 20 subclause 3? Or for example, a person is being tried in a court, and court has compelled him to answer or to tell what is the name of his favorite car. Can that statement fall under Article 20 subclause 3? The answer is no, because the word to be a witness against, to be a witness against refers to that statement which can be used against the accused, which can go against the accused. Only that statement can be taken into consideration under Article 20 subclause 3 for the purpose of the protection under doctrine of self-incrimination. Therefore, each and every testimony or each and every statement cannot be taken into consideration under Article 20 subclause 3. Only that statement can be taken which can be used against the accused, which can go against the accused in any criminal proceeding. Therefore, this was the main highlight of Article 20 subclause 3. And what else remains in Article 20 subclause 3 is uh, uh, the compulsion part I have already discussed, and where there is a voluntary statement given by the accused or the witness, that may be taken into consideration. That is a valid statement, but that should not go against the accused. If that goes against the accused, and the element of compulsion is however proved in the trial, then that statement is treated as invalid. Now, one more question arises if we further look into 20 subclause 3 deeply, that can the protection of Article 20 subclause 3 be taken where things are manifest? Where the things are can the protection of Article 20 subclause 3 be taken? Things which are physical in nature, which a person can see, can that be taken into consideration? For example, the accused is asked by the police officer that you provide me your blood samples, or you give me your watch. I want to send this watch for invest for the to the forensic lab. I want to send your watch because the police officer found broken pieces of a watch at the crime site. He want to examine that watch. Can there the accused say, no, 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 I have Article 20 subclause 3. I can exercise my right. You cannot compel me to give these watch, etc., or the belongings, or you cannot force me to give my blood sample. I will not give my blood samples because I have protection under Article 20 subclause 3. Can he do so? The answer to this question is such kind of evidences which are manifest or physical in nature, they cannot be taken into consideration while deciding the question of Article 20 subclause 3. Article 20 subclause 3 only deals with those evidences, and especially if we talk about the particular evidence, that is the oral evidence, which are within the knowledge of the person, which are within the knowledge of the accused, which are in his brain, which are in his personal knowledge. Upon that, Article 20 subclause 3 will apply. Which are things manifest, there you cannot exercise the protection given under Article 20 subclause 3. Therefore, it is clear on this point that if an investigation agency is asking for you, asking an accused to give his specimen signature, or to give his blood samples, or to give his fingerprints, or to give some material associated with him, he cannot refuse. He cannot refuse to that, because Article 20 subclause 3 does not extend to the physical things or manifest things. It simply extends to the knowledge. It simply extends to the knowledge of the accused. Knowledge, by in simple words, if we talk, what is there in his mind, what he possesses in his mental capacity, You cannot compel him to bring something out of his mind so that you are getting benefit in the investigation. You cannot compel that person. You cannot compel him to disclose something which is there in his mind, but you can ask him to provide something which is manifest. Therefore, a reasonable doubt would arise, which also was discussed by Supreme Court in 2017 recently, but the point is yet to be decided. Point has not been yet decided by the Supreme Court. We are waiting for the decision of the Supreme Court. The issue related to the compulsion upon the accused or the witness with respect to disclosure of the password of some uh, phone or laptop, you can say, or any of the gadgets where the data can be stored. Can a accused be asked to disclose, or to can a accused be compelled to disclose the password of his device? Can he be compelled? Now, if we look into the discussion which we are having since 1 hour, as per that, Article 20 subclause 3 would give protection to such person, because password is something which is in his personal knowledge, and if he disclose that, then certain things might be there in that device which may be used against that person. Then logically, Article 20 subclause 3 would protect that person from disclosing the passwords under compulsion. This is my personal opinion. Supreme Court's decision is still awaited. So let's wait for the Supreme Court decision upon this issue. But according to me, if a person is compelled, if an accused is compelled to disclose the password of his device in order to in order to proceed further in the investigation, then he may still avail the protection under Article 20 subclause 3. So this was all about Indian Constitution with respect to doctrine of self-incrimination. Now I would like to move to the procedural aspect of the article of the doctrine of self-incrimination. As I was discussing, when I referred to when I referred to section 161 subclause 2 of the CRPC, that the provision is in line with Article 20 subclause 3, and the same protection can be availed by any person under section 161 subclause 2, whether he is an accused or he is a witness. Any person can avail that protection under 161 subclause 2. And there was a landmark judgment of the Supreme Court, wherein the Supreme Court has held that this protection is not only limited to the investigation stage. This protection is not only limited to the investigation stage, because I was continuously referring to a term in my discussion, that the person should not be compelled, the person should not be forced to disclose or to give any statement which can be used against him in a criminal proceeding. By that means, by criminal proceeding, I mean to say that it includes all the three stages of a criminal delivery justice system. That is the investigation, the inquiry stage, and third one is the trial stage. At all these three stages, the protection against the self-incrimination is available to the accused or the witnesses, and the criminal procedure code laid down certain provisions which are essential to be discussed, to be referred before concluding the today's lecture on doctrine of self-incrimination. Because apart from constitution, the doctrine of self-incrimination was already enumerated in the code of criminal procedure and various other statutes like Indian Evidence Act before 1947. uh, and let's come to those provisions. And the first one is the Article 161 subclause 2. Article 161 subclause 2 basically talks about, let me share the screen once. Mm.
Sir,
I'm just concluding the topic, my presentation in next 10 minutes. I hope that will be okay.
sir, actually, next 10 minutes will be a little longer. Actually, we understand that these constitutional articles are quite lengthy and they might not be just completed in
Okay.
such a small lecture.
Let me not share the screen. I'll just refer to the provisions and I'll conclude it within 5 minutes.
Sure,
Right?
sir.
All right.
Thank you so much, sir.
Okay. So CRPC also provides certain provision. For example, Section 161 subclause 2, where at the investigation stage, if police compels an accused or a witness to give evidence against himself, then such testimony or such statement, if gathered, cannot be used against that person. And that protection under under section 161 subclause 2, the protection is available in the present case, that is the case under investigation, as as well as in any other case which might arise in future. So the protection available under section 161 subclause 2 is available in the present as well as the future cases. Whereas if you talk about inquiry stage, at inquiry stage, the compulsion can be through court. The compulsion to give evidence against the person himself can be through court, because that is the inquiry stage. And that has been covered under section 313, 313 subclause 4, which only provides the protection in the present case and not in the future case. So 161 subclause 2 was providing protection in present case as well as the future case, whereas 313 subclause 4 is providing protection in the present case only and not in the future case. Therefore, if a person is disclosing or giving any statement which may incriminate him in the present case, that statement cannot be used against such person in the present case, but that may be referred, or that is a conclusive evidence, or that may be a substantive piece of evidence in any other proceeding against that person that may come in future. So this was about the inquiry and at the trial stage also, accused cannot be threatened or promised by the court. Accused cannot be threatened or promised by the court to give evidence against himself. That was about the trial stage, when the court is conducting the trial. So these were the basically three stages which were carrying the various provision under which the accused is protected from being a witness against himself. This all was discussed in the case of Nandini Satpathy versus P.L. Dani, and therefore, as a concluding remark, we can say that protection under Article 20, subclause 3 is not limited to accused, but the broad principle of doctrine of self-incrimination is also available to the witness under 132 Indian Evidence Act, and also available to suspects under the same article, that is 20 subclause 3, and it is against, and any such practice which go against article 20 subclause 3 will be void and will not be admissible in the court of law. That's all from my side. Thank you.
Thank you so much, Keshav sir, for such a detailed webinar on these articles. Though I understand that such articles are so broad that these might not be concluded in such a small span of time, but then we are just obligated to end up in within a time limit. So I beg your pardon to the participants that we will not be able to conduct this question round due to the lack of time. But if there are any question posed, like I could see some of the questions and there might be some queries from the participants. I beg your pardon that may not be answered it right now, but I'm sure that your queries may be answered later on. Okay, now moving on forward to the vote of thanks. Before bef- Before conducting anything, I would like to express my heartiest gratitude to the head of law department, Dr. Professor Pallavi Gupta, that she provided us with such a great opportunity that we are getting enlightened about this basic topic from our alumni and from my senior, and of course from the senior of the participants. And then I would like to extend my gratitude to the faculties who have allowed me to be the anchor and be a part of this webinar, and to hear my senior again. And then I would also extend thankful to our guest, Mr. Keshav Gaur, that he has taken out his such time for this time from his busy schedule, and has come to us for providing this knowledge. Thank you so much, sir. And then I would also thank all the faculties who are present here in the webinar and has cooperated with us. I also extend a heartful thank to the participants who have been a quite good audience and has supported us and has been quite efficient with us while during this webinar. And Richa ma'am, do you wish to say anything else?
Keshav, please share your ID so that the student can send their question to you, and you can answer their questions there.
I'm sharing my email ID.
Yes.
My email ID is KESHAV.
Please write in the chat box.
Just a second, ma'am.
Also, I would quickly like to request everyone to just switch on their cameras, all the faculties and the students, so that we can take a virtual group photograph quickly before the webinar ends.
It's a humble request. Please open your cameras.
The faculty and the students, please switch on their cameras so that we can take a digital photograph of this webinar, please.
It's done. Thank you. Thank you, everyone.
Thank you so much, ma'am. Thank you, everyone, for being such a patient audience. Yes, ma'am.
Yes. Thank you, Keshav, for such a beautiful webinar and for such an informative session, as well as Keshav was not well. Yesterday, I have spoken to him. He was not well and he was suffering from fever. But then also, like, he managed anyhow. He has taken out his time. So once again, very thankful to you, Keshav, for sharing such an informative information with a student. And I hope that students are going to benefited with this information. And with this, thank you and all the best, Keshav, for your future. Thank you, Apurva.
Thank you so much, ma'am. Thank you.
Thank you.
Thank you so much, ma'am. With this, we have come to an end of this webinar. Thank you so much, everyone, for joining and for being a patient audience.